okay? One other thing I want to talk about, I'm going to send a video out to everybody. What's cracking down right now is with the MLS, it's not something new. It's been a rule in place for a long time. When you have a listing that goes on the contract in the MLS, you put a projected close date. If it surpasses that date, 7 days after, you're going to get a warning. Last month alone, there were $7,000 in fines in January. Okay. Now I'm putting this out to everybody. I'm going to make a video and show you what you need to do. When I have a listing and I go on the contract, put the projected close date. Let's say my projected close date on my contract is today, the 28th. I probably put 2 weeks out, like March 13th or March 14th, because if it closes anytime from today until March 14th, I can just go and hit it close that day, and I ain't got to worry about getting fined. So I automatically put that as my little system, because when you go in and you put whatever day, say you close on March 3rd, we just put March 3rd. Just a rule of thumb, because they're cracking down on that. The first is $100. The second one is like $250. In the month of January, there was $7,000 worth of fines. So I don't want our people to get that. Just make sure you're mindful of that. We have Mr. Davia. Gabriel's joining the company. He's coming on board with us right now, the next couple recently, and he'll be joining the war team. So welcome. We'll talk more about it later. I know you haven't prepared your speech, but we'll get you ready. And we got Debbie Business Day. Hey, this 11-page contract. Alicia, wind blowing in the hair all wild. You good? We got an 11-page agreement that we're going to talk about. I'm going to do this in 2 parts. So 2 parts, and we are recording this. We'll send this out in 2 parts. Do me a favor. Shut that door. So what I'm going to do, I'm going to try and make it through the first 5 pages today, okay? Because I'm sure it's a lot to unpack. And what I want to do, you know how we do, if there's got questions, we'll stop, we'll talk about it, we'll go in theory, maybes, probablys, possibles, thoughts, stuff like that. So we just get in a space where we make ourselves better. We got nothing but time, but we're going to try and do it in 2 parts, okay? Probably 2 parts. I've never gotten through this in 1 session because it's such a long agreement. So let's hop in and get to going right here. Okay, so this is the residential listing agreement. It's used for all residential properties, okay? This one went in effect on August 23rd, 2024. After all of the stuff that happened on August 17th, this is what they came out with. Most of it is still the same. And the only thing that really changed was in paragraph 5. So we're probably going to spend some time on paragraph 5 just to make sure people really understand it. But this is what you use if you're going to do any type of residential real estate listing agreement with a seller. This is the one you use. It's a TXR 1101. So the first part 1 is the parties. When you look at part 1, I think the most significant thing that I want to tell people is that part 1 should be the address, the current address of wherever the seller is. Sometimes we have the sellers inside the house, and sometimes we have sellers someplace else. I always get questions like, what address goes there? You put their current address there, whatever's applicable in their current information. This is a fake contract, right? It's a fake contract that I made up because some of that stuff is my information, but it's just fake, right? We just did that for the class. When it says broker information, I want you to put the broker address. I want you to put the broker's name. But when it says phone number and email, that should be your information. My policy is that your information goes there, not mine. If you want to have my information, there's an email. There's two separate email boxes. You can put mine in a second one, but you should want your information there. Part 2, the address in part 2 is the actual property that is going to be sold, and we need all the applicable data there. We've had situations where the legal address is so long, if you get one of those, that's where you would come down to special provisions in this particular box. For the most part, that's where you're going to put all the legal address. And the second part where it says known as, that should be the address that is known as. That's what you should put in Google Maps, right? You would not put lot and block in Google Maps, right? So that's what you put there. When you get to 2B, If you're new or if you're seasoned, I still think you should always look at this paragraph because it matters, right? We've had so many situations. Most times I get the conversation about TV mounts. TV mounts are mounted to the wall. So the TV mounts would stay, but the TVs you could take away, right? So when you're explaining, let's go from the perspective of a seller. I like to put that in perspective for the seller. If I'm explaining to the seller, I'm like, okay, anything permanently installed to this house is considered part of the sale. I always talk about TV mounts. I talk about pergolas and things bolted into the ground. I have that conversation with them. I even ask them during the listing presentation sometime when I get to this point, do they have anything that they have permanently installed to the house that they want to take, right? Because we got to have a conversation about it. I've had situations where this lady, this guy, he told me in the listing presentation, he said, hey, look, I'm taking my pergola. It was a Walmart pergola. And I didn't think about it. I was fairly new and day of closing, the buyer's agent sent me a picture of a cement block where the bolts was taken out and say, hey, the pergola was supposed to be there. I go back to the original conversation. He told me all this other stuff. They're telling me, hey, it was right there. They showed me 4 blocks. Guess what I had to do? I had to pay for a pergola. All right, I had to pay for a pergola. I tell you that story because I don't want you to pay for that. Right? So just have the conversation. If you get to stuff like that, I always tell people the same thing. Just make sure you put in exclusions. We're going to talk about it in 2D in a second, but just put in exclusions. I would even go a step further in the actual public remarks. I would put it in the public remarks in the MLS and say, okay, these things are not part of the sale. Okay, they don't convey. All right, to take it that step further. All right. So things like that, you need to make sure you have the conversation. If you can say, hey, Mr. Seller, why don't we take those things down before we even put it on the market? If that's a possibility. So people don't even ask for it. What they don't see, they don't ask for, right? Let's take those things down if you can. I tell everybody all the time, read the accessories. You'll be surprised. One of the most common things that we have conversations is about the security control systems. If you read it, they're supposed to be part of the accessories, right? You're talking about the ring alarms and ring mounts and stuff like that. Your seller is saying, hey, I'm taking that stuff. We have to put that in exclusions. We have to talk about that. We have to make sure that's on there. But I would tell you to read that. It has things about drapes and rods and curtains and all this other stuff that goes along with this paragraph. If your seller planning on taking that stuff, you have to make sure it's on the exclusions and it's actually spelled out for people. It's a huge thing that we have conversations about curtains and rods. Yep.
So Ring doorbell.
Ring doorbells. If you're new, I always tell people to read every word in this whole process. Look from both perspectives, from the seller's perspective, but also if you're the buyer's agent, look at it from that perspective too. This is what your buyer is expecting to get unless it is written into the exclusions. Keep that in mind. This paragraph always comes down to play, especially at different times when we start having these discussions about what stays and what goes. Okay, let's talk about where it says stove. I've had conversations with people, and the stove, if you go to different states, there's different rules for different states about what is accessories. In Texas says the stove has to stay. Doesn't matter if you can slide it in and out. It says stoves have to stay, right? If I've had a situation where a person, oh, I bought my stove. This is the super stove of all times. I'm taking my stove. Well, Mr. Seller, you probably need to get a replacement stove. You probably need to get a replacement stove. You can replace it with a different stove, maybe prior to put it on the market. Okay. So what people don't see, they can't ask for. Just a rule of thumb, you're going to have situations where people are saying, I want to take this and take that. You're the professional. You're the person who's got to tell them what's right and what they can and can't do. And a seller can take anything they want, but it doesn't come without consequences. If you take a stove out and you don't have a stove in the house, is it eligible for a VA loan? No. You see what I'm saying? So you got to have those types of conversations with people. You're going to take VA buyers out the game because they can't get a VA loan. So there's a couple ways to skin this cat, right? So yeah, we need a stove there, right? So you have those conversations, but our job as the listing agents is to make sure we explain to these sellers what this paragraph really means. And they don't really know what this paragraph really means. Now, in the event that any of these items are going to be excluded, that's what 2D is for, to in the listing agreement, to lay out what the exclusions are going to be. So jointly will automatically kick it over to an attachment. So you can go as long as you want. That's what I like about jointly. It will kick it over to an attachment. Okay. Any other questions? Okay. 2E, if the home was in a home association, then we need to have that checked off as well. All right. Any questions on this page before I go to the next page? Yep, you're right in pergola. Whatever between improvements and accessories that your seller saying, hey, if it fits in those two categories, but I want it, that's where you're right at it. Now, you don't stop right to take the extra mile when you put it in the MLS and you start to write the MLS description. I would put those exclusions inside the actual public remarks. Nobody can sit there and say they didn't know. Because if they're in confidential remarks, is only seen by the agent. Now you got to worry about the agent telling the buyer, but that's just personally where I work with. There's a bunch of them. It's going to take away the effect of you writing a description. You might have to put it into the confidential remarks. Probably should put it both places.
I was gonna say, can you do C remarks?
You talking about in the MLS?
And because if you want this thorough, beautiful
Correct.
description.
C remarks.
C remark or exclusion remarks.
Absolutely. Any other questions? Okay, let's keep on going.
Hey, Ben, sorry.
Yes.
Good morning. So one of the things that I do really quick I want to share is that I also advise the seller, on top of putting it on exclusions, I tell the seller to remove it before I schedule photos. If they can, whatever that is.
Number 3, pretty much what the price is going to be. You have to have a price to make this contract valid. All right. You can't just, hey, we're going to figure out later or whatever. That's not what is allowed. And you shouldn't have nobody signing anything without a price there. Okay. Without a price there. Simple as that. If the price changes before we put it on the market, you can go back and amend this, right? For whatever reason, but you can't have somebody signing this and saying it's a valid listing agreement. You can't have somebody signing this and to have a valid listing agreement without terms. It has to have a start date and an end date, which is in paragraph 4. So you have to have a start date or end date. It could be 5 days, 5 months, 6 months, 1 year, but you have to have a start and a finish time frame for it to have a valid contract, and you have to have a price. Now, I think this is a market-driven thing. It's a talent-driven thing, I think. I usually do 90 days, but right now in this market, I'm probably going to 120 days, probably 4 months. But it's what you feel comfortable with, what you think you can do with the listing, okay? 4B, it says if the seller enters into a binding written contract to sell the property before the date this listing begins, and the contract is binding on the date the listing begins, the listing will not commence and will be voided. So let's talk about this for a second. You go to a listing presentation today, and the seller says, let's start this listing May of this year. And you put May in there. You put a start date of May 1st. Now read that paragraph again. It makes a difference, right? A huge difference. What you get out of that? You don't get nothing if they sell it before then, okay? So when I tell you, I always tell people, I've been to many listing presentations and, hey, they're not ready. Most times when I go, people are not ready. It doesn't mean we can't start the listing today. Now, we have some other stuff down this agreement that we can not have the listing in the MLS later, but it doesn't mean that we can't start the gig and get the job right now today. Now, if I leave out of there and I put 3 months down the road, if they do anything to get this property sold up under contract, but prior to that, I'm entitled to nothing. I'm entitled to nothing. Now I'm going to show you how to. Hello.
We can hear.
All right. So keep that in mind, okay? So when you go out to these list appointments, I'm going to show you how you can do it. We'll have an example here coming up. So number 5, where the biggest change came about, right? Talks about broker compensation. Let's talk about 5A first. In short, 5A is there. It's supposed, if you use 5A, everybody see 5A, right? Then you also have to use in 5.2. I got that, right? So meaning that whatever you put in the 5A1A, that's the total amount that you're getting the seller to say, okay, I'm going to pay out, right? This is the total amount. You can do it in a percentage or you can do it in a flat fee. You have the option, right? It says below there, says if broker does not pay other broker that procures a buyer as specified in 5A, broker's fee in 5A1 will be reduced by the amount not paid to the other broker. Now, I want to talk about these two things right here, right? Because I want to read 2 paragraphs that kind of goes together, right? It says if broker does not pay, right? But I also want you to read, because I'm going to jump around here just for a second. I want you to go to 5A4. And when you read 5A4, it says broker will retain amount specified in 5A1 as a broker fee if there's no other broker that procures a buyer, including but not limited to transactions where the buyer representation, both seller and buyer, intermediary, or buyer unrepresented. Amount specified in 5A2A will be applied towards any fees a buyer has agreed to pay the buyer specified in the separate written agreement. So I want to go to those 2 because I get confused a little bit. Right, the first one I just read and 4. So let's talk about 4 first. 4 is okay if no other broker involved, they're unrepresented. The amount collected is still 5.1A. Okay, so I always get these questions. Okay, the seller found the buyer, and whether they A4 specifies that it's the amount in 5A1. Everybody with me? That always comes up. Hey, I list the house and buyer comes up and now they don't have a buyer's agent. What should I do? You should have a great day. That's what you should have. You know what I'm saying? You should have a great day. That's what you should have. And everybody looks all distraught when they're coming to like, oh, no, you got congratulations. Now, how you do it matters, right? But that's what's in the paragraph, right? Now, let's go back up to 5A1, right up under B. If broker does not pay the other broker, meaning that there is another broker involved. Okay? There's a buyer broker involved that procures the buyer as specified in 5A2. The fee is less that amount, right? So what we're saying is you can't keep the 6%, right? But that fee is reduced to that amount. So you would come in if, let's say, the other broker's paying the buyer's agent, but paying 3% on the contract. You have to reduce 5A1A by 3%. Everybody with me? Okay. We had this conversation a couple different times, and it's been confusing as we get into it, but it is. Let's keep on going. 5A2 is what you're agreeing to pay the other broker, correct? It also specifies as you get in this contract, everything has to be negotiated, even though it's in this agreement. It doesn't necessarily obligate the seller to pay the other broker just because they have it here, because everything still has to be negotiated in the contract. Now, what this does do, and this is the magic wand, it allows you, with the seller signs this agreement like this, hey, I'm going to pay X amount to buyer broker. This allows you to advertise that. If you're having the conversations with people that says, okay, look, I don't want to pay the buyer's broker and all this other stuff, and I just had that the other day, I would go to the stance of, you got to give me some ammunition to work with to at least advertise it. I'm not saying we're lying, but at least advertise it. In the event that if we have this listing, we keep on having conversations, the buyer's broker picking the phone, calling the listing agent. Listing agent says, no, we're not offering buyer agent compensation. And the feedback is, no one's coming to see this property. We're not even getting the opportunity to get the property seen. Why would we want to take that away from you, Mr. Seller? I think there's a conversation you can have with the sellers when they want to be really like bulldoggish and say, okay, I don't want to pay nobody, right? I get it, you don't want to pay nobody, but let's at least give me some ammunition to work with to advertise that you consider up to an amount to pay somebody. Because when someone calls me, I can at least sit there and say, seller will consider up to this amount in buyer's agent compensation. This doesn't obligate the seller to pay this amount, but it does give you the ability to advertise what this amount is. I think that's where we're getting some things confused a little bit. Does that make sense? Any questions about that?
So let's say you're offering 2% to the other side, and then after a month, you have that conversation, and they're like, okay, now we're going to do 3. Do we have to do an amendment to this?
Yes, I got to go amend this contract. Amend the list. Yeah. Even so, let's go with this route. Let's just say, which is probably the next segue into 5B. Right? 5B is without any compensation to the other broker. You just have that seller says, hey, no, we're not doing it. It's not going to happen. Right? Let's say they change their mind along the way in the contract. We just need to go back and amend the listing to reflect that there's a different form that allows us to go back and change all this stuff. The only thing I say about this paragraph, if you do have that conversation and that ends that way where hey, we're not going to do anything whatsoever for the buyer's broker, it is what it is. You work with it. It's not the end of the world. And you're going to have situations like that.
What if your client tells you, no, I want to pay the buyer's agent fee, and you're like, okay, what if I'll take care of the other agent? Can we do that as well?
You could. However, you're still.
Well, how will we write it?
I guess you're saying that in this case, the way you're saying is, okay, look, you have a 3% agreement that you're going to get paid by the seller to the listing broker. And of that 3%, you're going to pay something out of 3%.
Correct.
It can happen.
And how would I write it in the contract? Technically, you know, when
if you don't pay, you get paid 6%.
So she's talking about a different scenario.
I get this scenario, but like in this contract, the way you just explained it, there's no buyer agent. You get paid
the 6%.
correct? But if there is
The way this is written, she's talking about down the bottom. I think you're talking about if we just had 5B, right?
correct.
Okay, and then let's say 5B says 4%. Okay, I think she's talking about, let's just play this with numbers. You just say, okay, hey, I'm getting paid 4%, and all of a sudden a buyer broker comes along and they want to get paid. Of that 4%, you can do whatever you want because the seller says, okay, I agreed to pay you 4%. If it was 2%, if it was 1%, you can do whatever you want. All right, now it works, right? And then that'll be reflected on the 1 to 4 family contract or whatever differently, which is a different class. It's probably not the class for right now, but could you do it? You can do it. Okay. And I don't want to go into that right now because we'll go down a rabbit hole, but let's just stay on this page for a second. But could you do it? Yes, you could do it. Okay. Any other questions before I move on to the next thing? No? About land. Everybody's clear. Great. Okay, let's look at the next paragraph down there. Can somebody read it?
No authorization to disclose seller party buyer's expenses. Seller does or does not authorize broker to disclose to other brokers and prospective buyers that seller will consider contributing an amount towards buyer's expenses, such as buyer's brokers fees or other expenses payable by a buyer under a sales contract. Seller is not obligated to pay any specific amount and has discretion to determine the amount to disclose and advertise additional information such as specific amount of seller concessions.
All right, they got the TXR 1412, correct? That's what it says, 1412?
Yes.
Okay, so I want to go to two different things. So this is saying, okay, hey, look, does or does not. If the seller says does, then we need the TXR 1412. The TXR 1412 is a different form. We're not going over that today. But if it says does, then you have to have the TXR 1412, and the 1412 is going to specify in a dollar amount what the seller would consider up to towards buyer expenses. Make sure we use the right word, buyer expenses. The word we need to use, the word we need to educate ourselves with. Long as you stay in advertising, if you put buyer expenses, you can do anything you want out there and not be in any violation of anything. Buyer expenses, okay? Because buyer expenses could be all of it. Okay. So the safe word, if you're gonna do any type of advertising, you put buyer expenses, all right? That would be the safe word, right?
Both, right? So if the seller is in agreement, you're gonna select does, and then you're gonna complete it 1412.
Yes, you have to have TXR 1412.
But join is gonna populate that if we does.
Well, let's forget about joining for a second. I just want to make sure that if you know, does mean that you have to have the TXR 1412.
Two questions.
Sure.
So this is in addition to 5A. If it was just what you're gonna pay the buyer's broker and nothing else, then it would be does not on the bottom.
Correct.
Okay.
So if you go to 5A3,
Right.
it says seller, when this is checked off in 2, it says, okay, this amount up there says if they're okay with this 3%, that gives you authorization to tell everybody about the 3%. You just can't tell the 3% inside of the MLS, right?
And then my second question, this is for us to be able to advertise it, right?
Correct.
But when it comes to negotiations, whatever happens, this is for
Just that.
advertising only.
Advertise. The words the seller will consider up to blank dollars towards buyer expenses. That's the verbiage that you need to take and take it as your gospel for that concern. Now, if they say does not, you still have the ability to advertise that the seller will consider up to 3% in advertising, as long as it's not in the MLS forced commission, right? And you can say, if they checked off does not in advertising, you could still advertise seller will consider up to 3% towards buyer expenses. The safest way to do it is towards buyer's expenses. Seller consider up to X amount towards buyer expenses. I would like for us to get away from the word commission or BAC and just keep it simple. This is an amount towards buyer expenses. Buyer expenses could be all of the above, and we'll be safe in advertising if we took that approach from our company.
Understand correctly, when you say not violate, I know you're talking about the MLS, but they did authorize us because they're willing to pay a broker fee. That's why it's okay? to
So,
disclose it in-
the note down below is for anything additional other than what's in 5A2.
Closing costs or a home warranty.
Right.
Yes.
If it's additional things that they're like, so we had a listing, I just lost at Lost Willow, right? So in our TXR 1412, we had $14,310 in our TXR 1412.
Okay.
So when we advertise, we said, hey, look, sellers willing to consider $14,310 towards buyer expenses.
Okay.
Now, that included closing costs from the seller's perspective, closing costs and the buyer's commission. If you added that amount up, it came to 4.5%, right? And that's what they were willing to do. It was legal for me to put it anywhere I wanted, even inside the MLS. If you looked at the listing inside the MLS, I put in public remarks seller willing to consider $14,310 towards buyer expenses. I could not have said that unless I got that check, and I had the TXR 1412. So the combination of all those things together allowed me to publicly display it in the MLS, anywhere I want. All I did was put the amount of $14,310 seller will consider up to that amount towards buyer X. I could have done it differently and said whatever 3% advertise, did the math and put that amount, said, hey, sellers want to consider towards buyer expenses this amount. But I couldn't put the additional amount about the closing costs and all this other stuff. I couldn't do that.
Okay, you could have just.
Correct.
Got it.
All right.
No, if it's just like, guys, like using this lingo that you just used.
Could I advertise? I can advertise it as long as I say towards buyer's expenses. If you've ever seen any advertising systems come out, I've never said anything about buyer's agent commission. I will not say anything about buyer's agent commission. When people call me and they're asking, hey, look, is your seller considering, or is there compensation for buyer's agent? I'll say, hey, the seller's authorizing $14,310 to go towards buyer expenses. That's my response now. I don't even say commission. I've totally taken it out of my language now.
But what I'm saying is us having to respond the question if, what is the seller willing to compensate, can we just use that?
Use what?
Advertise it as seller is willing. For example, if it's just a 3% for the buyer agent compensation, can we just promote it like that? So that way they know, they don't have to find out if the seller is paying for the DAC.
You can, as long as it's not an MLS.
It has to be an amount, it cannot be a percentage. Because here's this amount.
So if it's in the TXR, you have to have the amount. If it's in the TXR 1412, excuse me. Depending on where we put it. So let's also talk about where we put it. If you're talking about placed in MLS, you can't say anything about commission. But the MLS also allows you to put it in a percentage. It also allows you to put it into a dollar amount of what they would consider towards buyer expenses. So you can do that in the MLS towards buyer expenses. Now, when you're talking about commission, obviously that can't be in the MLS, but you can put percentage, you can put whatever you want, as long as it's not in the MLS. Okay?
Sorry, one more question.
Yes.
If I read it again, it does say, and we're saying does not authorize.
No,
This one says such as buyer's broker fees or other expenses. So then we can't even say buyer's broker fees to market?
For my company,
Okay.
I don't want people saying it. I want them to use buyer expenses, no matter what,
Okay.
because it's all encompassing of everything.
I'm okay with that, but I'm saying if the sellers, no, I don't want you to disclose it. I want them to just bring me offers. And
If they say they do not want you to disclose it, then you can't.
you can't even say willing to do the 14,000 or minus the buyer's expenses and just do broker fees.
If they say does not, no, that's not. What are you reading there?
It says disclose to other broker and prospective buyers that seller will consider contributing an amount towards buyer's expenses such as buyer's broker fees or other expenses payable to a buyer under a sales contract. If the seller's like, no, don't disclose it, I'm willing to offer, they just don't want you to disclose it. They don't want you to advertise it.
So I want to make sure I'm clear about this. We have 5A1 and 5A2 filled out the same, but the person still goes down and says does not. That line 3A3, read that.
Seller authorizes broker to publicly disclose compensation for the other broker as specified in 582. So it trumps this one then?
Yeah, we can still talk about that amount,
Okay.
but
cool.
we just can't talk about, if he says does not, we can't talk about anything additionally.
Got it.
Because when they sign that, that's what they're allowing us to do. Okay? Questions? This is good stuff. Let's go to the next page.
I have a question.
Sure.
For example, if the buyer's agent calls you and they're adamant about, hey, can you please tell me about the compensation fee and all that stuff? Can you just tell them if you do the math with what the buyer's authorizing, that you would be able to figure out what the percentage is? Or how would we address that? Because some of them are like, I want to know what the percentage is.
You can talk about commission all you want. anyhow, you can advertise, you can do all you want, right? You just can't do it inside the MLS.
Those-
So if someone asks you, if someone called you, say, okay, what they offering for the commission, you can say it. I'm just telling you what I've chosen to do. There's nothing wrong with telling them. I've just chosen to use the words for buyer expenses because I just think it's just a safe word. Because I can't be quoted any other way. All right. I've chosen to use buyer expenses. It'll be okay. All right, let's keep on going. We have 5C and 5D. They break down what's earned and payable. I'm not going to spend much time on that, but I will tell you that really take some time. I guess if you're on your own to read it, I want to unpack something else in 5A, but that just defines what's earned and payable, okay? And it also talks about what's not payable. In that second paragraph there, it says, okay, buyer compensation is not payable if the sale of the property does not close or what I can't see. What's this?
Which one?
Yes, someone read that. Can you see that?
Property does not close or fund as a result of there's failure to deliver a buyer a deed or a title policy as required.
Thank you.
Oh, that's
Yep, that's it. So that's pretty much right. You know, if it does not fund, it's not payable, right? Now, but I do want to talk about 5E2 for a second, because we've had situations like this and people tend to ask me. In the simplest terms, it says, okay, look, if you look at 5A E1, we have about the breach of buyer. If the seller collects any funds, like earnest money, sales price, or damages due to the buyer breaching the contract, it does trigger a broker's entitlement to the compensation. Now, if you get to this point, there's probably lawyers. What I tell people, if something has happened like this, the contract does say that if the buyer breaches and the seller gets some form of payment, the broker is entitled to something. By the time we get to this point, there's probably attorneys involved. All right. So I just want to throw that out there. But it does say that sometimes we have this conversation, but that's what the agreement does say. He talks about service providers. Essentially, in this paragraph, it's simply just this. I don't need time. That you can receive payments from service providers. And just because you receive X amount of payment from some service provider doesn't mean the seller is entitled to that. When I explain it in the list agreement, if I receive payment for some service provider for whatever reason, Mr. Seller, you're not entitled to that. Keep that in mind. And now the big question, 5E3, other fees and reimbursable. We've had this conversation all the time, right? So in this regard, this could be, I'm trying to think of the situations I've had reimbursables for. I've had a situation where seller was out of town and they had their pool to be maintained and all this other stuff. I was doing it for them and got reimbursed for this type of stuff, and I put it in there. We made an agreement like, okay, this is what it was going to be for. You could have in there from anything from your pictures. You could have anything from any type of amount of work that you think you should get if they cancel the contract. All right, I've talked about this clearly for a long time. That's your prerogative, right? I think it has to make sense. You got a $150,000 listing, but you got a reimbursable of $10K. That might not make a lot of sense, right? Most people probably won't sign that anyway. So it has to make sense to people. But there's nothing stopping you putting some reimbursable fee in there, right? Questions about that one?
Have you had like service provider pay you?
Have I had service?
Give an example.
I got service providers paying me now. Yes. Okay. Now, I think where they're getting at least from Trek's perspective, is that you as a real estate agent as a business, is your loyalty or anything like that's being swayed because you got a certain service provider that you're getting paid by, right? And I just think that's where they're trying to go with this, that you shouldn't allow that to happen. Just because you're getting paid by loan, yeah, doesn't mean that you have to go here. You know what I'm saying? There's where you start having that conversation that way, right? I think that's where it's for. I think that's the intent behind the paragraph, right? Okay, let's go to 5F, protection period. 5F.
Hey, Ben?
Yes.
I'm sorry, before you go further, on E3, do we need to submit an additional form if we get compensated from a vendor or a service provider? Because there was a form back in the day, I've never used it, but I remember a form where the client would be aware that we're disclosing it.
Yeah, there is a form.
But do we need to use that form, or does this cover?
This covers that. Okay.
Thank you.
Now, we take extra precautionary measures here when you use True Title. Since I'm a partner at True Title, they're doing everything there at title company to put stuff in there for the people to sign at True Title because I'm a partner there. But if there was something, this paragraph covers you for that, right? Do we really need that form at True Title for the listings? Nah, this probably covers it. But it's just another safe spot for people to have. Okay, where else we got? Let's go into protection period. In short, with this one right here, I think this paragraph is really, when you read it, the totality of it is just trying to protect you as an agent or a brokerage for the seller doing business with someone that you may have brought to the table. That's what the whole basis is about this protection period. If you read it, there's a process that says you have to specify the amount of days after termination or cancellation by either party. Within 10 days after the termination or cancellation, the broker has to supply the seller a list of names they brought to the table. If you really look at the paragraph, it says, hey, Mr. Seller, if you do business with any of these people or their relatives, right, in this time period of the 60 days, then the brokerage is entitled to compensation. That's what it really breaks down. Now, if you don't turn in the list and all of a sudden you find out later that they sold it to somebody that you brought to the table, but you never turned in the list, you didn't follow the process, and you don't get any compensation. So the key thing is, if you do get a termination cancellation, turn your list in. If you don't, then you're not entitled to anything. And that's what this paragraph really breaks down. Questions about that one?
No, sir.
All right, let's keep on going. Page 4, the county, wherever county payable, we put up there, I think, for some other reason, jointly it's just putting USA. Have y'all noticed that?
Mhm.
Yeah, it's automatically populating USA. So I got to look at that. I noticed that this morning when I prepped this class. I couldn't put El Paso in there. Is anybody having that same problem? It was just me? Okay. Yeah, I couldn't put El Paso County in there. Have y'all had the problem?
Mhm.
Yeah, same thing? Okay.
Let's say we sell a property in Huntsman County. Is this the county of our brokerage or the title company?
I think we're
It should be the county of where the property is at, or where, that's what I think it should be. But I will answer, I will get that specified, because that's a good question. I don't know the 100% answer on that. For G,
But I think it should be where the property is at, correct? Because we're listing the property.
But it says where it's gonna be paid in.
Yeah,
So
it
it
should
should
be where
be,
your broker's at.
right.
Broker or title company? Because where the escrow is happening is where the payments are happening.
I think that's supposed to be where the property's at. I think so. But I'll specify. When I don't know something, I'm totally fine with saying I don't know. Never came up, but I will find out. I will get the answer. But I've always been taught, don't know if that's the right thing. Because of the recording, it makes me think about how it's being recorded. But I could be wrong. Okay? I'll get back to you guys. Escrow authorization. In short, a seller's authorizing the broker or any escrow agent to carry through with the transaction and do the things that they do at the escrow. Okay. All right, listing service. Here's where you have the conversation about, hey, we went to the listing appointment today, but they're not going to be ready for 3 months. This is where this comes into play. And you have some options. The first option they have up there, they start talking about, hey, look, if the property is publicly marked, MLS rules require that the broker must have it in the MLS in 1 business day. And then they define a little bit more about what's public, right? Now, I want us to take away from here is that bold print in there. This also goes towards the seller too. Okay, so we've had issues sometime with folks that their seller did something publicly. The seller put it out on social media. The seller sent out emails to, let me give you a serious situation. You get these investors and they have their own list of potential buyers. You're going to get this listing agreement signed and everything's good. They got this property. And then they turn around and blast it out to their peoples. Okay. Now it wasn't the agent, it was the investor. But by this definition, the agent has to have this property in the MLS in 1 day. So there's where the issue becomes at. We haven't really had it lately, but 2020, this was a problem. This was a big problem. So my advice to you, if you're the listing agent, is to make sure you explain it to them the right way if you have the investors. I've never really had a big issue with folks, but you still need to be explained. Common person, never sold a property, don't know, they're excited. You go take pictures and you send the pictures over to them. You're not going to put it in MLS for a couple of days, but they start telling their peoples and putting it on social media. Technically, you got to have it in MLS by 1 day. All right, that's what that bold print is, right? Now, 6A1, it goes down and says, okay, look, if you checked off 6A1, broker will list one or more.
According to the following.
Correct. And then if you use A, you have to have it within 5 days from the date that we start. So that date we start, in this case, it was today, right? So this will require me to have it within 5 days. If I checked off 6A, I'm required to have it in the MLS in 5 days, right? Now, same example, we start today, but there's stuff they got to do, home prep, got tenants in it, you got treatments, you got to do all this other stuff. And you do a guesstimation about, hey, we think we can have it on the market in 45 days. You could come down to 6A and put that number there. If they did sell it anytime today until that point, you're still entitled to a commission, right? So you got hired today, but they end up going to sell it and got somebody else. You're still locked into a payment, right? And you just specify it during those days. So it's always best to, if you can, to get it signed that day or whatever and just do the guesstimation of how long it's going to take. Can you put it on the market prior to that date? Yeah, of course. You don't have to wait till the 14th day to do that. You know, as long as you got the seller to agree and you can put it on before, go ahead and do it. Okay? Yes.
Is there any rules on how many days?
I don't know. I don't think there is, but I'll check.
For example, I'm gonna help them prep the house. Price take us 30, 60 days.
Oh yeah, that's well good.
Okay.
I thought you was talking like you want to say 2 years. I'm like,
Oh, yeah. You went for 90 days.
I've done stuff almost to 6 months.
Okay.
Yeah.
Okay.
I'll double check, but yeah, I've done stuff up to 6 months for sure. Most times, that's when I tell people, these people that think about the people that told you, hey, I'm going to list next year. This is what you come and do it for. Hey, we can still list you next year. Let's hire me now, and we can list this property in 90 days. There's nothing wrong with that. Just write it the right way. Now, if you say, okay, hire me in 2028, I got to go do some checking, okay? All right, but maybe I'll get a actual. I want to know what the intentions behind the form when they wrote it. The broker alerted committee, what did they have in mind? I'm sure there's some other stuff behind this to say how many months or whatever. Okay, but good question. Now they say do not check if prohibited by the MLS services. So there's some MLS services that doesn't allow you to do that. Our MLS service allows you to do that, right? Okay.
Question, sorry.
Yes.
Could you be putting, like,
So when you do coming soon, there's rules in the MLS about coming soon, right? And there's a definition there. And I think the current definition is coming soon. Right now, you have 7 days. If you put something coming soon, that's where the MLS bylaws and regulations would supersede this. And that's when they're making that note. Do not check this if the MLS doesn't allow it. We have to go to our MLS rules. And our MLS rules, if you did do coming soon and you put in the status, you have to have it in the MLS by 7 days. So that's where that supersedes it. And that's what they're talking about the next paragraph about your MLS rules, right? If you have 6, the broker will not file listing in MLS. If you're checking that block, you can't put it in MLS. Just basically telling the seller, say, by marking this, if you read that paragraph, it's like real estate suicide. If you read it, that's what I say. I say, this is real estate suicide. You don't let me put it in MLS. You can read it.
Why would they refuse? What are they?
Oh, there's several reasons. You got people, that's public officials, you got FBI agents, because all this stuff comes public record.
For
Famous people, things like that. Yeah. Now remember, this form is for all of Texas. If you got out in the Houston areas and stuff like that, you probably got some people that need some protections and stuff like that. We have people here in El Paso that probably need protections that don't want their stuff out publicly.
How will you advertise it?
You do the best you can.
Let's say like Matthew McConaughey lives in Austin.
Right.
He might not want it on the MLS, and you're gonna have to find other ways. But a house is big, that would be a reason.
So if it's not on the MLS, you can still use social media and emails and stuff.
Whatever, yeah, you could. You could do stuff like that. To me, it would be to protect the identity of the seller for those particular purposes. You know?
Will it apply like to post it like in MLS, but with none of the seller's information?
You can't do that. The MLS won't allow you to do that. You have to have the seller's information and stuff like that. You can't even make it active. Okay, let's do page 5, and we'll stop here after this one, because I usually break this down in 2 parts. So page 5, listing content. In short, if you read that, listing content, photographs, the seller is authorizing you for the following. There's nothing to check off here. It's just part of the agreement, but they're authorizing you to use photographs, images, graphics, video recordings, virtual tours, drawings, written description, remarks, narratives, pricing information, other copyright elements. But this is just something to read over. I think you should just read it and make sure they know what they're signing. It does specify at 7 alpha about access to the property. Authorizing access to the property means, and it gives a meaning, but essentially by reasonable standard, hey, we're gonna be able to show other brokers, their associates, inspectors, appraisers, contractors to access the property within reasonable times. All right. I think that's a good conversation to say what's reasonable in the conversation with the actual seller, what's reasonable for them, and try and see if we can accommodate that. You got 7 Bravo. A broker may engage with the following companies to schedule appointments and authorize others to access the property. The only thing I think we really have down here is showing time. If you go to other parts of Texas, they got several different types of showing systems. Key box, they are signing. There's nothing to check off here, but if you see 7, it talks about the lockbox on 7C1. You have to get the authorization to put the key box on the property. It says if tenant occupies the property at any time during the listing, seller will furnish a broker a written statement. For example, this is another form, the TXR 1411, signed by the tenant authorizing the use of the key box, or the broker may remove the key box from the property. Okay, so you got to get the tenant to sign off on it. You have to have a tenant. You just can't have a tenant inside the house and selling the property, and they don't have the right. They don't have access. All right. Now, somebody want to read that last paragraph, 7D.
When authorizing access to the property, broker, other brokers, their associates, any key box provider, or any scheduling company are not responsible for the personal injury or property loss to seller or any other person. Seller assumes all risks of any loss, damage, or injury, except for the loss caused by broker. Seller will hold broker harmless from the claim for personal injury, property damage, or other loss.
Unless I personally break something, I'm not responsible for anything that happens to your house. But keep it simple. You're gonna get drilled on questions.
So question number 7B. For example, if it's a military couple and the husband is deployed, technically one of the owners, right? we still have to secure the TXR.
It's only just a tenant.
Technically, he lives there, she's a boy, so we're not required to do it.
Is there a lease agreement?
No, if it's a, military couple, and wife is here, the husband is employed, they both own the house.
No, they're owners. They're the owners, they're not tenants.
Okay, so it's only.
Yeah, only tenants.
Okay,
All right, only tenants. And the reason I specify, let's define the word tenant. They're on a lease agreement, they're month to month, whatever, that's a tenant, right?
okay.
If they own the house, don't have to have. In short, with 7D though, to be clear, if you didn't break it, you're not responsible. I've had several conversations about this. It gets hairy in this whole thing, okay? And I think that's a good stopping point. That's the first 5 pages. We have 6 through 11, but we'll pick this up 6 through 11 on the second iteration. It was a long one, y'all. It's a long one, all right? But it's got a lot of information in it. So I want you guys to be able to explain it and know what they're signing. So when I speak this in a listing agreement, I usually speak it in a sense, hey, Mr. Seller, Mrs. Seller, you're signing that, and I fill in the blanks. Hey, you're signing that, boom. I usually specify it like that, so they hear it from what they're signing onto. Okay, and that's the best way to explain it in my book. If they need examples, I usually give stories, especially like when they start talking about showings, and I started talking about jewelry or weapons or medicine and stuff like that. Hey, you have to secure that because you are liable for weapons, drugs, stuff like that, right? I've had showings and stuff like that, and agents call me like, there's a shotgun standing right in the middle of the door, and we had kids, and I'm, hey, Mr. You got to secure that stuff. You know what I'm saying? So these are the conversations you're gonna have, and I like to make sure you understand how to make that work with them and talk to them in the way they need to have it. Okay. All right, that's where I'm gonna end it there, and then we'll pick up from 6 through 11 next time. Okay. I'll send this out on the chat as I normally do.